So, thanks very much, Christina. A warm welcome in this first ECOLL seminar promoted by the labor law community. Particularly a warm welcome to our distinguished speakers of today, who I'll introduce in a minute. We are already about 40 in the room, more will come. This ECOLL seminar is especially dedicated to early career scholars. I will illustrate the structure in a second, but let me first recall the symbolic importance of holding a seminar today. Today is the 20th of May, and for Italian labor lawyers, this date carries two, I would say, indelible meanings. Not only is the 20th of May the date when the status worker was enacted back in 1970, but unfortunately, it's also the day when in 1999, Massimo D'Antona was assassinated by the Red Brigades. Now, for those who don't know him, D'Antona wrote extraordinary pages on many labor law issues, and probably I would say the best ones deal with the very topic that we're dealing with today. So with the status of workers and the scope of application of labor law. And in fact, in its writings since the 80s, but again in the 90s, he wrote very much about subordination and beyond subordination. And not by chance, the first speaker of today's panel titled his last book, published in January 2021, Beyond Subordination, building inter alia, of course, on D'Antona's findings and on Alain Soupiot's findings, and engaging in a dialogue with the subsequent scholars. And let me now come to how our seminar is structured. Now, Professor Adalberto Perulli from the University of Venice will present two thought-provoking papers, one published in 2020 in the European Labor Law Journal, and one which is about to be published in 2022 in the same European Labor Law Journal. Then we have a stellar, I would say, panel of speakers who will engage in a discussion with Adalberto, taking their own perspective from their own national system. And in alphabetical order, we have David Mangan from Maynard University. Ireland, you have Thomas Pasquier from Paris-Nanterre. We have Jesus Cruz Villalón from Sevilla University. And last but really not least, I would say again, Dulcis in Fundo, Manfred Weiss from Frankfurt. So thanks very much to you all for being here. Now, the idea of this ECOLL seminar was first elaborated by our dear colleague Tanya Sachs from Paris-Nanterre, and then it was picked up by myself and by another group of younger colleagues that you can see in the room, and who will animate the debate and who will assist early career scholars this afternoon and tomorrow morning. The idea is to let us all reflect on cutting edge topics. This is just the first one, but we are also thinking of organizing a second one in the second semester of 22. And on those cutting edge topics, we would like professors to present their ideas, to discuss amongst themselves, and then to let early career scholars interact both with them and amongst themselves. And the idea to stimulate this interaction was to work on case studies. So the organizing committee of today has elaborated 3 case studies on which in the afternoon and tomorrow morning, the younger scholars will work. So I think the time now has come to introduce the seminar of this morning. Ideally, our frontliner, Professor Perulli, will present his papers in about 30 minutes, and then the discussants will have 20 minutes each, with the idea to leave some space for an open debate towards the end. So without further ado, Adalberto, I think you can both start sharing your screen and speaking whenever you're ready. Thanks very much to all. Okay, now we can see part of it.
Can you see the slides? Luca,
part of it, you should just put presentazione. Yeah, that one. Yes, now it's super clear. Yeah, and it works. So thanks, Adalberto. I will keep the time, and then I will not interrupt you, but tell you something when we are close to the 30 minutes. Thanks very much.
Thank you very much, Luca, and thank you very much to all the organizers of this seminar. And good morning, everyone. As Luca said, I and my colleagues from labor law communities have decided to start from a couple of articles I have written on the subject of employment, subordination, and self-employment. This is not meant, of course, to be a limitation of our debate. Is just a starting point for our reflections. The first paper I present deals with the category of subordination to highlight a double movement, I would say, of legal systems in the face of the changes occurring in the labor market, in the firm, in the production field, and faced to the growing need for protection emerging from these changes. And I have defined this double movement in terms of a new expansive trend in labor law. So let's consider the first movement. The first movement is within subordination, and it is aimed at broadening the category of subordination through interpretation, adapting the notion of subordination to the new social and the new productive context, where some traditional features of subordination are being lost or getting obsolete, while the needs for protection are definitely in the rise in the world of work. And this interpretative trend plays out in different ways. For example, I give you some examples. One first tendency that has regarded civil law systems like Germany, Italy too, dates back to the recent past concerning the change in the qualification techniques, and it consists in the replacement of the criterion of subsumption with the more flexible typological method. Another example is about teleological interpretation. Teleological interpretation is a way to speak about the so-called purposive approach, where subordination and dependency are reinterpreted in a broader sense as expression of democratic deficit in the work relationship, and therefore focusing on the vulnerabilities of workers. Another example regards the partial revision of the traditional subordination tests and indicia. For example, I give you an example from Italy. In Italy, the jurisprudence coined the term soft subordination, subordinazione attenuata, to qualify as employees, workers not being subject to specific directives. Another example, in France, the jurisprudence coined the concept of organized service organisé, to qualify workers inside an organization as employees, even if there is not a power of direction in a strict sense. Another interpretative tendency completely disregards traditional indicia, traditional indicators that are now considered as obsolete and inadequate, and is putting forward new criteria, new indicia, new tests. For example, in Italy, there was the attempt to introduce a new concept of subordination based on the so-called double alienation of the worker with respect to the organization and the result of the work. In the state of California, a jurisprudential tendency, and then the legislator has introduced the ABC test, which greatly expands the notion of subordination, as it requires to exclude the application of labor law, that the client, the firm, needs to prove not only that the worker is not subject to managerial prerogatives, managerial powers, but also that the worker carries out the same activity for a plurality of clients. Therefore, I would say not being economically dependent, and the client must prove that the activity of the workers is not attributable to the normal production function of the firm, of the client. So this interpretative movement basically reaffirms the traditional binary division between employment and self-employment, but this subordination, the sphere of subordination, is dilated by internal lines, thus capturing new forms of work that arise qualification issues, like in the case of platform work, of course. Is platform work to be considered as employment or as self-employment? Of course, this has been a universal question with very different answers from system to system, and even within each system. And scholars and even jurisprudence generally hold that most of platform work is to be considered as subordinate, even if is qualified as self-employment. However, in my opinion, this cannot be considered as a final answer for many reasons. First of all, because platform work is not uniform, but varies according to the different platforms models of organization. Secondly, because the notion of subordination the notions are not homogeneous, but have different legal connotations. As a matter of fact, the United Kingdom tests are not the same compared to the Italian test, for example, and are not the same in Spain or in France. Thirdly, because there are systems where there are intermediate categories which can actually include platform workers, as it happens in the UK, for example, with the category of workers, and also in Italy with the category of collaborations hetero-organized by the client, which is a new category introduced in 2015 with the aim of extending the employment regulation to forms of work that do not have the characteristics of subordination in a strict sense. Anyway, what I would like to underline is that through these internal and adaptive ways, subordination has expanded by way of interpretation, even if at the cost of some, I would say, interpretation stretching. Okay, I give you an example. In my opinion, this interpretation stretching happened when the French Court of Cassation stated that riders are to be considered as employees because they are controlled by a geolocalization system. This seems to me too little to consider riders as being employees. Another interpretation stretching consists, in my view, in considering as fictitious the freedom enjoyed by riders in being able to decide whether to work or not. This is a problematic issue to me, especially in those systems where the reciprocal obligation is fundamental to classify work as being subordinate, as in the UK system, according to the mutuality of obligation test, but also in the Italian system, I would say, where there is a legal definition of employee as being one committing oneself to provide work, with the consequence that if workers can refuse to accomplish such obligation, it's very problematic to me to say that here, in this case, there is subordination. Now, this second, I'm sorry, this is the this is the slide, the second slide. Now, the second movement. The second movement is external to the category of subordination and somehow leaves this category aside. The movement consists in extending labor law in a more or less universalistic or selective ways outside its traditional scope, thus creating a situation of selective universalism beyond subordination. Within this trend, the main role is not played by the judicial interpretation, of course, but by the law. The law creating intermediate categories, and we may spend endless time to talking about whether it is a really third categories or it is about self-employment subcategories, but this has minor relevance to me. The reasoning underlying this legislative extension through intermediate categories is different from the first movement. while in the first movement, in the case of extension through interpretation, it is the juridical category of subordination being expanded. In the second movement, the expansion of the protections involves the traditional scope of labor law beyond subordination. This movement has important theoretical and systematic implications. As a matter of fact, in this perspective, subordination ceases to be the only category of labor law. Labor law is being expanded while its basic category, that is subordination, is not being expanded. Labor law, therefore, becomes labor law in general, including self-employment law in its different forms. Furthermore, this second movement shows a different rationality, where the contractual type is not so relevant in order to apply the protections, like in the binary vision. But what is mostly relevant is the need for social protection of workers, regardless the nature of the work relationship. So the type of contract loses relevance, whereas supra-typological, or if you prefer, supra-typical category acquire relevance, like in the case of parasubordination in Italy, or like in the case of the category of economically dependent self-employment. Parasubordination and economically dependent self-employment are different categories, but they are not a contractual types. They are actually categories open to many contractual types. And in addition, we have also a broader category, the so-called solo self-employment, recently appeared in the guidelines of the European Commission aimed at overcoming the prohibition of collective bargaining for self-employment. In other systems, the categories beyond subordination may be subjective, that is not referred to a type of contract, but to the social conditions under which individuals operate, as it happens, for example, in France with the mechanism of assimilation of self-employment workers provided for by the Code du Travail, for example, in the case of the unsalaried manager in the commercial distribution fields. What is relevant here is not work as being subordinate, but work has a legal category. And this is Massimo D'Antona, Luca. This is Massimo D'Antona. As a legal category requiring universal protections. Therefore, in order to conclude and sum up this first part of my speech, the binary constructions stating that protection are only where there is subordination, according to this different movement, is no longer adequate. Protection must be provided for where there is a social need, without looking for subordination at all costs, Therefore, the horizon of labor law is broader than that of subordination. This statement, this principle, labor law is broader than that of subordination, regardless of the presence of misclassification. And this is very important to me, because if this extension of protection should only be applied to false self-employment, we would performing no extension beyond subordination, just because false self-employment is not a juridical category to which protection should be extended. It is anything but the dissimulation of the existence of an employment relationship. Now, I would also say that the two trends or movements that I have described may also coexist. And the coexistence of these two movements is also provided for in the proposal for a European directive on platform work. On the one hand, there is in this proposal the introduction of a rebuttable presumption of subordination. And this is consistent with the first trend I have described. But on the other hand, the directive provided for that a series of protections concerning the modes of operating of the algorithms are also applied to self-employed workers. And this follows the logic of the second movement. Of course, international labor law too seems to provide social rights guarantees also beyond subordination, but I don't have time to deepen this issue. I just would give you this slide where we see how the mix between universalism and selectivity of protections is just achieved in some systems, such as Italy, France, Spain, United Kingdom, Germany, Canada, of course, with different techniques and different graduations. Now, if I have time, I think I should recall some points within the second article, critique of self-employment, because it is actually a continuation of the reflection I have conducted so far, and perhaps has some repercussion in legal terms. As a matter of fact, in this paper, I tried to analyze the binary construction on the basis of a critical analysis using Marx and Kojève. I'm not going deep into details, and I refer to the paper. I'm only saying that my thesis is based on some points of the Capital, in particular the Trinity formula, where Marx clearly to me, of course, talks about work in general and not only about salaried work as part of the process of capitalistic production. And in the same way, I found the Hegelian dialectic between master and servant relevant within COGEV because COGEV reformulated the master and servant dialectic in the logic of the capital. In fact, according to COGEV, the capital forces the bourgeois that believes to be working on his her own to work for the capital, just like the servant. My intention was to demonstrate that perpetuating the contrast between subordinate work and self-employment, between working for others and working on one's own, means not being able to understand that in the capitalistic system of production, all productive work is always an activity performed in favor of others, and to some extent, alienated work. After all, even independent work is now an alienated form of work that is going to be subsumed in the technical economic system. For sure, in such cases of alienated self-employment, there can be differences in intensity within the different situations involved. For example, we may have less or no directive power of the client, but a significant presence of organizational power of the client and economic dependence of the worker. Or we might have less or no organizational power of the client, but we can have a strong economic dependence. The combination can be multiple. Of course, the dimension of power and heteronomy is not foreign to the word of self-employment and is also expressed in forms other than the directive powers, which is typical of subordination. We have many different situations. I'm referring to my paper, but in conclusion, I believe that there is or there should be better a change of regulatory perspective within labor law. It is, first of all, a methodology change in the relationship between categories on the one hand, like contractual typology, fattispecie in Italian, Tatbestand in German, and so on, category, legal category on the one hand, and on the other hand, the juridical effects. I think that rather than pursuing subordination at all costs, as I said, I think it's necessary to build an expansive set of protections that overturns the traditional regulatory logic. Instead of starting with the categories, contractual typologies, and so on, to get the rights, let's start from the values. Let's start from the principles of labor protections. And then on the basis of concrete social needs, let's conceive the protections policies, and finally get to the rights. Consequently, labor law should have the following characteristics. Be rationally aggregated. The protection must be rationally aggregated on the basis of values and ordering principles relating to work in all its form and application. I'm referring here at the Article 35 of the Italian Constitution. Tend to be indifferent to the types of contracts and connected to the idea of personal work. Be universal, but modulated according to the different situation of social need expressed by the workers. And finally, labor law should be constitutive of a real, inclusive, universalistic, and selective system of rights, of course, in a wider labor law conception. I stop here. Thanks you very much for your attention.
Thanks very much to you, Adalberto. I think it was it was incredibly interesting. Two papers, but more importantly, two parts of your reasoning. You took many different perspectives from the contractual, philosophical, and at the end, epistemological perspective, so the one based on values. And I think there's really food for thought for our discussion now. And thanks also for having respected in a very, very strict way the timing. It was simply perfect on time. So the second speaker, so now we will open a structured discussion on Adalberto's paper. And we have asked 4 colleagues to engage in such a dialogue with Adalberto. Now, the first one is David Mangan. You can see from the slide his many affiliations. So I would say, David, thanks very much for being here. The floor is yours. You have approximately 20 minutes.
Thank you, Luca, and thank you, Adalberto, for the invitation to speak here. I've had the pleasure of reading these 2 papers. The first one that Professor Perulli presented, I chaired at the ILO Decent Work Conference. And the second paper, through my involvement with the European Labour Law Journal, I can say is online right now as an advanced article, and it is coming out in the very next issue of the journal in paper form. So what I'm going to focus on is the UK. I'll also talk a bit about Ireland. If I can move the slide. What I'm going to do is use Professor Perulli's discussion as a reference point, but I will talk briefly about what's happening with employment status in Ireland and the UK. So here, the main difference, what we have with these 2 common law jurisdictions is in Ireland, we have the traditional employee self-employed, but in the UK, as Professor Perulli noted, we have a different status. We have an employee, worker, and self-employed, and there's a 4th category called an employee shareholder, which, especially for Italian colleagues, it may be a bit laughable that basically you sign your employment rights away for some shares in the company. And if you think that the shares mean something, they actually don't really give you the kind of shareholder power that we read about in the newspapers. The starting point for both jurisdictions is a statute. And what we see here is the statutes are not very helpful in terms of their definitions. And I draw your attention to Professor Perulli's 2 writings, the fallacious alternative of working for others or on one's own account, as compared to the self-employed. And then labor law systems historically privileged subordinate labor. Whoops. Sorry, I'm just messing around with my own slide. The object of the social protection referred to civil or commercial law for the cases of self-employment. What's being referred to here is that if you are self-employed, your only recourse is really in the common law jurisdiction through commercial contract. I also provided some pictures for everyone. If you're in withdrawal from not traveling for the last 2 years, I thought you might want to see some of the photos. So we have the few tests, and I've outlined them here. These tests, it's in the UK, it's not like, and these are used in Ireland. These tests are not used independently. What we really have is a mixture of all of these. So if we look at the last one, the mixed test, ready mixed concrete, this is more what the courts are using. Two that stand out that are more discussed are economic reality, and Professor Perulli mentioned the economic reality test in his 2020 piece, and then the mutuality of obligation part. So let's look at this in application. We have, this is a key decision in the UK. AutoCleanse was about people who were car washers, and they were, according to the defendant, employed as independent contractors. But, and I've provided you with the key parts here, they had no, if they're independent, they had no control over the way in which they, they have no control over the way in which they do their work. They have no control over their hours. They don't have any real economic interest in how the work is done. They cannot source materials for themselves. They work in teams and not individuals. AutoCleanse is an example of what we see particularly with the platform economy, the extreme oversight of the employment type relationship, but calling it self-employed. So having all the hallmarks of supervision, but not, but claiming that this is not an employment relationship. And part of this is what has been referred to in Professor Perulli's papers as the purposive approach. The relative bargaining power of the parties must be taken into consideration in this factor, that the parties, the workers had no opportunity to bargain this. It was a take it or leave it kind of scenario. And if they were really self-employed, they would have had more of an option. So in AutoCleanse, they were found to be, employees. But we have the intermediate category of worker, and this is the relevant statute. You might have heard of the Limb B worker in the UK case law. And Limb B refers to section 230, subsection 3B of the Employment Rights Act 1996. Now, I think based upon Professor Perulli's two readings, I think we need to be a bit critical. Why is there this intermediate category? What is the purpose of it? Why would a worker have fewer protections than an employee? So in the 2022 article, and that was the last part of the presentation, there could be a suggestion that this really facilitates a capitalistic approach to work, that this middle category is sort of a compromise in some ways, that it allows this intermediary status to fit into a business model by curbing some of the protections, but not leaving these individuals entirely exposed. And we saw that early on with the what's called the Pimlico Plumbers case. This case was Mr. Smith, a very English surname, was a plumber hired by Pimlico, and he could perform the work that he was provided, or he could ask another Pimlico plumber to substitute for him. The idea here is, and in UK law, if you do not have to personally perform the work, then you can't be in an employment relationship. Now, the Supreme Court viewed that differently and said, well, the substitution clause was limited in this case. It was limited in that Smith could only have another Pimlico plumber. So if we imagine that Pimlico hired a roster or a group of plumbers, Smith could only ask another Pimlico plumber to substitute for him. He could not substitute anyone else. And for this reason, the Supreme Court said he was in an employment relationship and he was a worker. What that meant was, and we see this in the Uber case, workers have the protection of national minimum wage, which is about £9.50 per hour in the UK. They have holiday pay protection, but they don't have the full suite of protections. So in the Uber case, which you may have heard of from last year, the court explored this limb B, and they provided some commentary that may seem a bit odd for an English court. They said the starting point is not the contract. We start with the statute. Now, as I said, the statute is not entirely helpful, but what I think the Supreme Court is trying to say is we start with the wording of the statute and we're directed by that. So if we look at this quotation that I've provided, if the court is saying they only looked at the contract, that would be providing, and I'm looking at the last sentence that's underlined, they would be providing Uber with the power to determine for itself whether or not the legislation designed to protect workers will apply to its drivers. So the point that the Supreme Court is putting forward here is the legislation was extended for protective purposes. As Professor Perulli said, this is the orthodox idea of labor law. And if the starting point was the contract, that would be allowing the employer, in essence, to dictate what the relationship is. And in fact, they refer to the AutoCleanse case. They say, well, we need to look at the relationship. We need to look at the economic reality. And the economic reality may not match with what the written agreement states. So just looking at here. Yeah, so the last bolded portion, but there is no legal presumption that a contractual document contains the whole of the parties' agreement, and no absolute rule that the terms set out in a contractual document represent the parties' true agreement. So we have this mixture of a written agreement and the conduct between the parties. So in Uber, the court found that the Uber drivers were allowed minimum wage and holiday pay. Now, as an added point, aside from these two, we've had a decision from the Amsterdam court about this case, where the Uber drivers had to go to Amsterdam to get the data to show what was minimum wage, how long were they working. So this is an added aspect, I think, that we need to keep in mind. But the impact of Uber was fairly profound if we look at Uber committing to paying minimum wage, holiday pay, and a pension, and then recognizing a trade union to represent the drivers. Now, in terms of self-employment, the UK identifies two versions, and I've outlined them here from the 2014 decision of Clyde. One is where people who carry on a profession or a business on their own account enter into contracts with clients or customers to provide work or services for them. The second is what we're looking at with the worker status. So as was mentioned, the worker status is this sort of hybrid idea of it being in a subordinated position, but not necessarily independent. Now, I think it's important to bring out, well, why is self-employment so much more of an issue now? And I suggest to you, if we look at the data from the UK, we use the Great Recession as a departure point. And here I've provided some data that as of 2014, 15% of the total workforce were self-employed individuals. If we look at the numbers between 2008 and 2014, employment rose by 1.1 million, but the vast majority of that rise was self-employed people. So as opposed to before, when we had the orthodox labor relationship outlined, what we have is, in fact, a very significant change in the composition of the workforce, where we have many more people, arguably because of the Great Recession and the massive loss of jobs, people moving to employing themselves. Now, I'm not going to go into detail about Yodel, but Yodel, I think, is an important part of the UK discussion because it asks the question, is a worker compatible, the worker status in the UK compatible with EU law? And I'm going to note that, where did it go? This case seemed to hinge in part on the substitution clause. And I'll draw your attention to the last 2 bullet points on this slide. Yodel retained a veto if the person chosen does not have a level of skills and qualification, which is at least equivalent to that required of a courier engaged by Yodel. Now, I don't know what that means. What would be a person of equivalent skills and qualification? But putting that aside, in Yodel, the court seemed to suggest that this clause was important in determining that the suggestion I got was that B was not an employee or a worker and was in fact self-employed, because the substitution clause meant there was no subordination. And the question I pose is a substitution clause a key part of this discussion? Yeah, so I'm referring to the latest article by Professor Perulli, self-employment contract, which excluded the extension of the protections attributed to the employment contract. The Civil Code matter-of-factly left self-employment in the hands of the market. So here, Yodel, in Yodel, B is left to the commercial contract or contract law arguments that are available. Now, I bring this up because Ireland provides an interesting example, and this is the only Irish case I'll look at. Domino's Pizza had delivery drivers, and they had to sign up for when they were available. And then once they were on that roster, there was a contract made which retained mutual obligations. Now, of interest, the court here said that mutual obligations can occur in what's called an umbrella contract, and that mutuality of obligation did not require an ongoing provision of work and requirement to perform that work. And the last bullet point here, I think, is interesting. So if in Ireland, they don't have a worker status, I think we have some suggestion, at least by the courts, that maybe a modern means of engaging with workers is necessary. So there seems to be a bit of a push for an intermediary or at least a bit more of an expansive view of what is an employment relationship if the worker status does not exist there. Here too, we had a substitution clause. But in this substitution clause, the court said, well, these people are employees because they could only substitute another driver of Domino's, not anyone else. And I draw your attention to the Pimlico Plumbers case where we had a similar point. So for an employer, is the way around this to say, well, you can substitute for anyone, substitute anyone for yourself? I'm not sure if employers will be keen to do that. necessarily to allow such a wide spectrum for substitution. But I'd remind you that Yodel did have a veto, and it was still found to be at least the suggestion was it was in a self-employed relationship. Now, briefly talk about, and because it was mentioned, the Platform Work Directive, where we're looking at forms of organizational subordination. I really question the legal presumption here from the in the Platform Work Directive. I'm not sure, first of all, how workable this provision is. The ETUC analysis suggests that it captures a wide variety of employers. And I think in the first part of this presentation, Professor Pruli suggested we can't overextend the matter. We can't make this so broad that it loses meaning. So I wonder if Article 4, subsection 2 of the proposed directive goes too far in some ways, or is too encompassing, that it doesn't provide for more discrete distinctions. Also, I asked, who are the people affected by the Platform Work Directive? And data from this month from the ETUI suggests that there are 12 million platform workers. 3 million of them are main platform workers, meaning in the study, main platform workers were those who drew the majority of their income from platform work. So here we have the idea of people who are mixing employment. Who are those people who draw exclusively from platform work? And there are issues there. But then what about people who have a full-time job and seem to supplement income? And by supplement, I don't mean that this is necessarily extra income. It may be that people are combining the two forms of work in order to make ends meet. So I've ended with this quotation from the 2020 article, where it was outlined 2 different ways of achieving an expansion of labor law. And I just leave you with the question of to what end the proposed directive really leads us. Thank you for the time.
Thank you. Thank you very much, David. That was a great, you really engaged in a great, to a great extent with Professor Peruli's papers, in particular, both, so to say, on the internal side within subordination, where you stressed the idea that, for instance, in Uber 2021, the Supreme Court did not start from the contract, but instead from the status. And this mirrors very much what Adalberto was saying about from a subsumption to a typological method of qualification. And then outside subordination, you mentioned quite aptly the role of these substitution clauses that in the debate are becoming more and more important in the case law. And I think that would be also picked up to some extent by other colleagues in the discussion. Now I have Thomas Pastier from Paris Nanterre. So thanks very much, Thomas, for being here. I will leave you the floor. Again, you have approximately 20 minutes. In case you have slides, you can share. In case you don't, you just go and turn on your mic. Thanks very much, Thomas.
Thank you. Thanks, Luca. I have a slide to share, but it doesn't work. I think I'm going to send to Tanya, and maybe she could share it. I'm sorry.
No problem. We can do it while you speak. And
yes, and Tanya, I will
start the
Tanya,
slide.
je viens de te l'envoyer par mail. Est-ce que tu peux le partager?
D'accord. Tu m'entends pas, mais j'ai dit d'accord.
Ok. Thanks a lot.
Mais je l'ai pas reçu. Je ne l'ai pas reçu. Ah, ça y est, c'est bon.
Ok. First of all, I would like to warmly thank Tanya and Luca for inviting me to participate in this beautiful working seminar, as well as all the members of ECOLL organization. Immediately, I would like to apologize for my terrible and horrible French accent. I will try to do my best. The purpose of my presentation is to offer a comparative law perspective on the hypothesis developed by Adalberto in the two texts under discussion. Yeah, thanks, Tanya. Firstly, I must specify that the two texts, yes, perfect, thanks, Tanya, are of a rather different nature. One is devoted to the legal and jurisprudential evolution of the notion of employee, is rather technical and analytical. The second one, devoted to the critical analysis of self-employment, is more epistemological and prospective. However, the two texts and the two postures are based on the same analytical key, that of a rupture between the legal categories, law, and social reality, facts. Adalberto's postulate is therefore that of a mismatch, of an epistemological rupture, but not according to a poor vision of the opposition between law and facts, but according to a rich vision of a rupture between the construction produced by law and form of constitution of the social reality in capitalist system, notably by reference to the writings of Marx. Are we convinced? Yes, without a doubt. Law is indeed a mask that mystifies the category of the social and necessarily masks the reality of the relation of production in capitalist system. However, two remarks should be made. First remark, if law undoubtedly has a function of masking reality, it also has a function of instituting and legitimizing the social. Also, as following Antoine Jameau and the hypothesis developed in the book Le droit capitaliste du travail, we can say that law as a branch and as a knowledge about this branch participates in the construction of the social reality. Second remark, if law constructs the social, it is not the only one to produce knowledge about the social. Adalberto's text underlines this in the best way possible. Trying to understand social reality requires an interdisciplinary approach, combining law, philosophy, classical and political, sociology, and history. Thus, if reality is probably never completely attainable, the knowledge that constitutes it can be object of knowledge. Let us return to Adalberto's text. What struck me most was the importance he gave to ideology in understanding what the law and the reality it claims to capture. Like the hypothesis developed by Boltanski and Chapiello in their book, The New Spirit of Capitalism, Adalberto asserts that the vision that one can have, both of employee-worker and self-employed workers, is based on an ideology, an axiology itself. Are we convinced? Yes, one more time. In order to grasp the significance of this, we will look at the double break that emerges from the analysis of Adalberto's text. Firstly, the break between qualification and protection. And secondly, the break between ideology and protection. Maybe, Tanya, you can change the slide. First one, qualification and protection. My analysis focuses on the first, yes, perfect. The first text dedicated to the evolution of the notion of employee. Adalberto starts from the observation that qualification of employee is determined by subordination, and that the qualification of employee determines the scope of labor law. Is there any originality here in the link between qualification of a concept and an attached regime? Certainly not. However, it should be remembered that there are two main cultures of application of labor law in Europe. One based on the employment contract and the other on the employment relationship and the concept of worker. However, since the concept of worker is an autonomous concept of the EU law, the action of CJEU acts as a unifying force in understanding the scope of labor law. From the text, I shall retain two ideas. That of the judicial expansion of the qualification of employee, and that of the tension between the judges and the legislator in determining the boundaries of subordination. Thanks, Tanya. Adalberto's text first presents the different tools and techniques available to judges to qualify employment relationship. The text distinguishes a typology of worker figures: subordinate, past subordinate, self-employed. I'm not sure. I think this is c'est celle juste d'avant. Thanks a lot, Tanya. A typology of subordination and self-employment indicators: personal power of direction, control of activity, coordination of the activity, economic dependence, economic reality tests, and a typology of models: existence of a legal definition of employee or subordinate worker versus lack of legal definition. And maybe the idea of a greater flexibility in systems without legal definition, for example, in French law or in common law, probably emerges. Next slide, please. Thanks, Tanya. Then Adalberto points to an expansive tendency of judges in the qualification of the notion of employee. We can only agree with this hypothesis in French law. However, it should be pointed out that the tendency is not only linked to the lack of definition of employment contract. It is more necessarily based on the difference between the definition of the economy of employment contract and the normative effects attached to it: subordination versus protection, risks versus power, and the judicial qualification of the employment contract or relationship. As Antoine Jameau has well shown, the definition of employment contract is based on a subordination link. And the employment contract, in the employment contract, the subordination link and the employer's power are legal effects of the existence of the contract. Without subordination links, there is no employment contract. But at the qualification stage, the situation is different. It is a question of determining a state of subordination, not only a link. mixed of facts and law with a view to apply protective rules. And then the analysis is necessarily more flexible. The stakes are as much legal and they are economic and social. From this point of view, French law is probably closer to English law with economic reality than, for example, Italian law. For understanding, I will take the Uber case of the 4 March 2020. This case is quite enlightening in this respect, because also the Cour de Cassation does indeed consider the traditional indicators of subordination link, directives, control, sanction, and the court interprets them according to the economic and social configuration of the case. Lack of its own company, integration into the company created and organized by Uber, submission to Uber commercial contracts. And it seems to me a clear distinction should be made between the legal definition of an employee and the judicial recognition of this statute. Then, next slide. Thanks, Tanya. Following this, yes, maybe I think it should be okay. Following this, particularly with the regard of the digital economy, Adalberto recalls the tension between the action of judges through requalification and the special legal statute put in place by legislator. Adalberto then discusses a different option for regulating legally self-employed but economically dependent workers. That of extending labor law to parasubordinate worker, as in France, by means of the mechanic of partial or total application of labor law without an employment contract, by assimilating self-employed worker to employees. This is the first way. The second way is a creation of a third way. For example, parasubordinate worker, the worker, or the economically dependent worker. In the light of French law, the hypothesis of third way is probably more complex and pernicious. For example, in 2016, the French legislator built into the Code du Travail a protective legal statute for self-employed platform workers, the so-called social responsibility of platform. It was questioned whether this protective statute was simply a statute open to self-employed workers, or a mandatory statute with the effect that all platform workers would be self-employed. In a view of the case of the Court of Cassation, in particular, for example, the Take It Easy ruling of November 2018, or the Uber case of March 2020, it could be said that the platform workers could be employed, but the legislator does not see it that way. On the pretext of thinking about a third way, he set up a social responsibility for platform, and it is actually trying to introduce a normative prototype of self-employed worker into the labor code, the Code du Travail, according to a degraded system of protection, and while the exclusion of employment relationship is not obvious. Also, the reflection on the third category between subordination and self-employment is not devoid of a political ulterior motives. This brings me to the second part of my speech about ideology and protection. Then, as Adalberto shows particularly well in the second text, the construction of the opposition between subordinate and self-employed worker is an ideological construction. Let's be clear, law is an artifact. It is not meant to describe reality, but to norm a reality. However, what Adalberto showed is that the opposition between subordination and self-employment as a function of masking unitary reality of labor in capitalism, in capitalist system. According to Adalberto's beautiful formula, there is employed labor force and self-employed labor force, but all of which work for the capital. I will retain three ideas from this text: that of a unitary conception of work without adjective, that of the existence of a power in self-employment, and that of an axiological refoundation of self-employment. Next slide. I'm sorry, Tanya. Perfect. As Adalberto points out following the contractualization of work by the Civil Code, there was no binary conception of work. There were operations involving in the hiring out of service and a plurality of situations, as the Americans, the home workers, the domestic, but rapidly, production relationships required the construction of a boundary between the worker in the workshop or factory and the others. Several managerial writings have clearly shown the link between representation of labor as subordinate worker and the birth of the factory and the organization of the workshop. But what must be remembered is that the jurists have played a great role, not only in masking the relation of production, but also in instituting and legitimizing them. In French, for example, the creation of labor contract at the end of the 19th century was based on a dogmatic coup de force. Firstly, by a rereading of Roman law, and secondly, by legitimizing the labor contract as a contract of subordination. Next slide, please. I'm so sorry, Tanya. Thanks a lot. The slide play. Okay, it doesn't matter. Apart the fact, then I'm going to speak about the power in self-employment. Apart from the fact that the opposition between the subordination and self-employment is a construction, it masks the reality of the power relations that exist in the field of self-employment. Adalberto shows this very well. For example, the power to modify the object of obligation, the existence of instruction in contract of mandate, agency. There is power in self-employment. Then how to react this? I think that there are two complementary and non-exclusive paths. The first one is to pay attention to the protection of the fundamental rights of all workers, including self-employed. That was a path proposed by Alain Suppiot in his report in 1919. The idea can be explained with a question. Are self-employed workers not entitled to protection of their right of participation, to the right to collective bargaining, to the right to health, to the right to have a decent wage, to freedom of expression, to protection of their personal life, to the respect of the rule of equality and non-discrimination policy? I think a reflection must be carried out in this sense. The second way is to renew the legal doctrine about contract. Following, for example, the analysis of Pascal Lokiek, we can consider that the register of the contractual will is inadequate to grasp the expression of power in the contract, and that it would be advisable to think of an autonomous register of acts of power in the framework, with a gradation at the weakest protection of the vulnerable party by public policy, followed by a control of contractual prerogatives of power by protection of legitimate expectations. And at the strongest, a law of contractual power with the requirement of a procedure and a control of justification. These two ways of protection seems to me to be complementary and deserve to be considered at the same time. Last idea, it's okay for the time? Okay, thanks. The axiological refoundation of self-employment. One of the richest and more interesting perspectives of Adalberto's text is the invitation to refound the axiology of self-employment. Alain Suppiot has spoken of autonomy, insubordination, and allegiance in self-employment in order to mark the emergence of the same ideology of management of work, subordinate or self-employed, by project and results. According to the work of Sophie Bernard, a French sociologist, there is today a new spirit of employee with the figures of associate employee, the deserving employee, and the quasi-self-employed employee. But I think, like Adalberto, that there is also a new spirit of self-employment. There is worker with that of a worker who is legally independent but subject to the aims and requirements of the productive process of others. The reserve army, like Marx said, is today both that of employee and of the integrated self-employed worker, subject to the ends and aims of capital. Adalberto rightly proposes that the spirit of self-employment should be rebuilt around freedom in work of the mind, and a mastery of ends and means. I agree with this analysis, but I have a decisive question. Affirming freedom in work means saying workers taking back control of the meaning of their work. Giving meaning back to work and putting it back on a human scale, as the sociologist said. However, what kind of refoundation are we talking about? Is it a rethinking of work as a whole, because giving meaning and control over work concerns both employees and the self-employed worker? Or is it rethinking of a self-employment exclusively, with a clear divide between subordinate and quasi-subordinate worker without control over meaning, and truly self-employed worker made up of a freedom and meaning from and in work? That is my question, Adalberto. Thanks a lot.
Thanks very much,
And
Thomas.
thanks, Tanya.
And yeah, and thanks, Tanya, for the nice cooperation. Well, I think your intervention, your discussion of Adalberto's points leaves up many questions open. In particular, these last questions that you just mentioned are definitely crucial. So now on an organizational point of view, I have received messages to let all participants have 5 minutes break, particularly because of the density of our presentations today. So if you all agree, being now 11:3, I would leave 5 minutes and then be back with Jesus Cruz Villalon's presentation at 11:08, 11:10. If you all agree, we can leave the session on and just turn off the videos, and then we will be back just in a few minutes, the time to wash our hands. Thanks very much, and I will see you in a minute.
Christina?
Tania, je prends un second.
Oh, mais j'arrive pas à enlever le partage.
Ok.
Mon ordinateur est... Bon, je vais quitter la réunion, du coup, comme ça va enlever le partage, d'accord? Et comme ça, je...
Ok, après, je te réadmets. Je prends juste une pause de 30 secondes. Merci. So it's 11:10, and we have still two distinguished speakers to welcome. The first one is Jesus Cruz Villalon from the University of Sevilla. We all know him very well. Thanks very much, Jesus, for being here and for engaging in discussion with us and with Adalberto's papers. Jesus, you have around 20 minutes. Thanks very much.
Thank you very much, Luca. Good morning. I would like to begin by expressing my gratitude to the labor law community, especially Professor Marcia Barbera and Professor Adalberto Pedulli, for their kind invitation to participate in this seminar, which allows us to contrast common debates from national perspective in a process of strong convergence. I apologize, but I haven't time to prepare any slides like the colleagues who have preceded me in speaking. I agree with Alberto Pedulli that the starting point is that we are facing profound political, economical, technological, and social changes that are very similar in all countries. In particular, I would point out that in the face of similar phenomena in the past, which provoke a close debate within the European legal and political culture, with a strong tendency towards Eurocentrism, we are currently facing converging changes in the sets of society that are increasingly more globalized. This, in an emblematic way, is manifested in the fact that these transformations and therefore debates not only occur in the set of developed economy, but also in the so-called emerging economies. To mention what is happening in the American continent, because it's what is best known to me, these changes and debates are also present in Latin America, which are influenced by the labor legal culture of continental Europe. In my opinion, this circumstance derives from the fact that the determining causes of the transformation that we are experiencing in recent decades derive from the same factors in the set of reference societies. With being able to go into details, I agree that there are essentially four most influential causes. First, the irreversible process of economic globalizations. Secondly, the centrality of the service economy. Thirdly, the great process of technological innovation, which in an emblematic way is present in the digitalization of work. Fourth and last, the new form of organizational outsourcing activity, such as complex forms of project work or networking. In any case, the fact that the most relevant causes of the change processes are identical in the globalized economy as a whole is compatible with the fact that their impact is of a different nature between one group of countries and another, in the same way that there are diverse legal responses found in each of them. Indeed, regarding the impact of these changes, in some countries, the concern is focused on informal or irregular employment due to the lack of effectiveness of labor regulations. In other cases, the difference comes from the fact that the rates of self-employment in each labor market differ notably in quantity terms. Finally, the way the vulnerability or insecurity of workers is expressed is of a different intensity and nature in each of the countries. For these purposes, One of the great debates has focused on the alleged increase in force of self-employment, with the hypothesis not yet confirmed in general terms of a sharp drop in the rates of subordinated jobs in the labor markets, along with the emergence of a large number of vulnerable self-employment, linked on many occasions with a lot of job insecurity and precarious pay, much higher to those typical of traditional subordinated workers. It's provoked parallel change in the effectiveness of labor protection typical of subordinated workers under the traditional institution of labor law. However, before entering into these debates on the legal status of the most suitable and efficient work in modern societies, I believe that other contribution elements and derivates of these processes of change should be pointed out, albeit briefly, because they converge on similar problems. Indeed, in the first place, it can be seen that while in the past the distinction between work and leisure marked a clear border, which did not require any explanation, confusing situations are beginning to arise in which apparently no productive activity is being developed, but in sociological terms, they are evolving towards fields close to work itself. These are situations in which there is sometimes a tendency to what we would call run away from work, as one more example of the run away from labor law. Let us mention situations such as amateur activities in social networks that end up receiving funding and proposal for their continuity, volunteer work in non-governmental organizations that involve towards professional activities in them, strictly training activities within the company that become productive jobs, transfers tasks towards consumers, replacing strict productive jobs as a new form of prosumers. All these examples and other additional ones that could be thought of lead to the necessity to define legally which activities involve productive work in the strict sense from those which require a legal protection regardless of the legal nature attribute. Secondly, taking into account that this change caused the appearance of entities of a very diverse nature that play an uncertain role in the labor market and employment, but in any case, try to avoid being considered as companies. While in the past, it was easy to identify an actual company, now it is not so easy in the face of the emergence of so-called liquid companies, which try again to escape from the legal responsibility derived from the rules of legal protection of workers, regardless of whether they are autonomous or subordinated. Therefore, as appreciates to act in terms of protection of work, whether self-employment or subordinated work, it is essential to identify the legal nature of this institution, which try to run away from the legal condition of entrepreneur and in particular of employer. For this purpose, in addition, the line is not a single one, but there are successive and diverse, and we must distinguish different situations. From the Spanish perspective, we can differentiate the following situation from less to more dependent on the burdens, obligations, and responsibilities that could be attributed to them. In the first place, media or platform instrumentally used as a work vehicle, a plain tool, but act in areas always external to labor market. Second, entities that act as intermediaries between labor supply and demand, which must be qualified as employment agency in the sense of international labor organization and must submit to the regulation. Although these entities try to hide it, they act as authentic employment agency that can act both in the field of self-employment and subordinated work. Thirdly, entities that act through digital platforms that, although they only accept that they are as intermediaries, actually go beyond that to the extent that European Union Directive on Temporary Employment Agency could be applied to them. Fourth, entities that provide service to users and consumers who must be recognized as entrepreneurs regardless of whether the workers who act in the connection with them are self-employment or subordinated employment. Fifth, those companies that additionally have the status of employers for employing subordinated workers. Going now to the reality of self-employment, for long decades excluded from the scope of labor law, there is no doubt that the change that are being experienced causes a situation of notable weakness in the working condition of sales employees, derived from a strong contractual imbalance with is calling for a system of legal protection from the public authorities. In these terms, at the moment, a practical unanimity is detected in this objective of the need for the intervention in order that the traditional protection of the weak contractor, typical of the subordinated worker, must also be presented with respect to self-employed workers who in sociological terms we would call vulnerable workers. However, the unanimity of objectives seems to disappear when it goes on to determine what would be the best way in which this protectionist discipline would be carried out. The most convincing attitudes of the necessity of to overcome the most classic model of action on the labor market, exclusively focused on subordinated work, are committed to the need to guide legislative action towards the approval of a singular labor statute of worker or worker statute for all persons, regardless of the nature of the contractual relationship through which the service are provided. Since it is a very ambitious objective and a profound change in what constitutes the current model of labor law in European legal culture, it would start with different types of approaching formulas. In some cases, it could be a question of debating on the possibility of interpreting that the recognition of certain labor rights in the constitutional text or in the International Fundamental Rights Treaty allows assimilating the term worker with any person who directly provides a productive service for another, therefore not exclusively referred to subordinated workers. Other authors have proposed or tested the creation of intermediate figures such as parasubordination or economically dependent self-employment. In any case, what cannot be hidden that there was widespread attitudes of a strong distrust of regulation based on statute for all jobs, including regulation directly aimed at protecting self-employment. Basically, mistrust is located in extreme position, which could be summarized into opposite attitude. On the one hand, it is detected some authors that think the protection expansion operation, including all jobs, could provoke an effect of deterioration of the protection of subordinated work, and with it, a loss of identity of traditional labor law. On the other hand, at the other extreme, other groups adopt a high defense of the classic conception of the free enterprise and free market competition, which, according to their opinion, would go against the introduction of traditional labor institutions to the field of self-employment. Beyond the fact that I understand that with the passing of time, both objections can be overcome, it should begin by noting that self-employment as a whole is an extremely complex and diverse reality. In particular, it should be highlighted that the category of autonomous work today is a draw or mixed bags in which all jobs that are non-subordinated and being included. It is purely a negative idea of what subordinated work is not. In other words, the realities of self-employment are very varied and diverse. So, in my personal opinion, there is no single answer in terms of all them being able to attend to with the same framework of protection, or that in all cases this protection be maybe of the same intensity. In terms of approximation, for the purpose that we are considering the phenomenon, at least in Spain, it would be possible to differentiate the following realities. In the first place, in some legal system, certain situation of work developed under a system of strict subordination by decision of the legislator are excluded within the scope of subordinated work and is necessarily derived towards the regulation of self-employment. Secondly, in the opposite sense to above, we are faced with a situation in which work is carried out in conditions of total autonomy, but that by legal decision are necessarily incorporated into the scope of application of labor law. Thirdly, cases in which the self-employed provides service within the framework of outsourcing phenomena for client company, in such terms that there are elements of contractual imbalance manifested by different circumstances: economic dependence, heteroorganization, management with third-party technological means, etc. It would be what in the Spain Academy would be called alienation in the market, or in the Spanish legislation qualified by economically dependent self-employed. Fourth, cases of freelancers who provide service directly to users and consumers, therefore outside of the framework of outsourcing system, but where a third party appear that directly or indirectly define the professional conditions with expression in identical terms of contractual imbalance. The third party can be private power, as would be the example of commercial franchises, as well as a public power, which appear when the self-employed carries out an activity qualified as a public service, as in Spain, in the case, for example, of taxi drivers, ambulance drivers, and certain types of lawyers. In fifth place, we would find self-employed workers who, although inserted in the labor market within a context of outsourcing service due to their strong contractual position, do not perform in a scenario of contractual imbalance, but on the contrary, their autonomy extends to an action in the field of full contract equality with the counterparts. In the sixth and last place, the supposed ideal of self-employer worker who identify as some who neither provide service within the framework of outsourcing system nor his professional condition are predetermined by third parties. In summary, the variety of situation prevents a single and uniform legal response of all situations of formal or theoretical self-employment. In Spain, for example, we have at least 3 statutes. First, the traditional worker statute for the traditional salary workers, although with many varieties in the intensity of protection according different groups. Secondly, the statute of public employment with internal differentiation between 2 categories. Thirdly, the self-employment statute, which internally differentiate between the ordinary self-employment and the economically dependent self-employment. In the end, it is about establishing a model of a broad legal diversification in the protection of different workers. Thank you very much.
Thanks very much, Jesus. That was, I'm just picking up some of the many reflections that you discussed here, and it was very interesting that you also looked at the other side. So you also looked at the employer's side, how the role of the employer is blurring and what the role of intermediary is. And it's very interesting, this last snapshot that you gave on the statutes of self-employed and traditional workers in Spain. I think that was very important for our discussion. Now, the last, but again not least of our speakers today is our dear Manfred Weiss. We're very honored to have you here, Manfred, for your experience in the field and the imprinting that you gave to most of us in our studies. So Manfred, thanks very much again. You have around 20 minutes. Thanks.
Thank you, Luca. Well, thanks also to you, and thanks to everybody from the labor law community for having invited me. Being the last speaker, I'm in a situation where you all are tired already, so I try to be very simple. I will, of course, not use any pictures, you know, I'm not a friend of PowerPoint, but I will divide my short intervention into 2 parts. In the first part, I will take the German example to demonstrate the inadequacy of the criterion of subordination, which, by the way, the inadequacy has been proved long before there was a platform economy. Therefore, I think the focus on platform economy should be given up. That's wrong. You know, it's a much broader issue. Secondly, I will afterwards, well, also in reference to what Professor Perulli wrote, make some reflections on how we might go in the future. Well, if you look to the history in Germany, you will see that for a long time, we had no definition of what is an employee. We only have such a thing since 2017. I come back to this. What we had long ago was a definition of a self-employed. Self-employed, according to this law, was anybody who essentially is free in organizing his work and in determining his work time in presumed to be self-employed. Well, this doesn't say much, but it was a sort of, how should I say, pillar from where we could start to think, what is an employee? And then you started and said, well, everybody who works in a situation of subordination, of personal dependence, that's an employee. Nobody knew exactly what that means, but we could go on without any problem. Until the early 60s. In the early 60s of last century, we had a case which showed clearly that we couldn't go on like this anymore. I give you the case briefly. There was a leading senior hospital physician-in-chief, one of these kings, you know, in medicine. And well, he was deciding everything in the hospital, what medicine is about, you know. He was deciding what kind of medicine. He would decide when things had to be done, when there was a surgery or I don't know what, everything. But the big question in this case was, is this person an employee? And it was a bit difficult, you know, to discuss in terms of subordination. But at the very end, our Federal Labor Court came to the result, yes, it's an employee. How did they do this? Well, they said, almost all of the physician's capacity to work is taken by the hospital. It's absorbed by the hospital. Therefore, this person is an employee. This sounded for many people, including myself, ridiculous. And then we started a big debate. What does this subordination mean? And the more we debated, the more we found out it's meaningless. And then we had a big wave of cases in the 70s. And the cases were all more or less the same. There was a huge group of freelancers in the media area, with the journals, with the newspapers, with the radio, with TV, and so on. And as you may know, in the 70s, in the early 70s, all over Europe, we had a phase of big unemployment for many reasons. And there, of course, these freelancers were the first to be kicked out because there was no protection against unfair dismissal. So the freelancers discovered their love for employment. And they said, in reality, we are employees. Then they all went to court. And we had hundreds of cases, you know, all the same. Are these people employees or not? And then the question was, are they working under personal dependence, under subordination? And the court, the Federal Labor Court, would say two things. First thing, which is now everywhere the same, the wording of the contract is irrelevant. Whether it says freelance or not doesn't mean anything. Relevant are only the facts. But then, of course, we have to qualify the facts. The question is, how do we do this? And then the trend which we have until today started. They developed lots of factors which indicate that there is an employment relationship. To just give you some idea, first, the enterprise expects the individual to be always ready to accept new tasks, or the individual is not free to refuse tasks offered by the enterprise, or the individual is to a certain extent integrated in the organizational structure of the enterprise, or the time required by the individual for performing the tasks for an enterprise is rather long, and things like that. You know, we had a whole set of many, many factors. And then the court had a genius idea. The court said, well, not an individual factor, not a single factor is relevant, but the whole of these factors have to be seen as an entity. What does this methodologically mean? Well, it means that the court has an enormous leeway to say what the court wants to say. And the so-called indicators and the criterion of subordination are nothing else but an alibi to arbitrariness. That's what it is, you know. It's arbitrary whether you do it this way and that way. And by the way, that's what I see now everywhere when I look through these Uber decisions and what we get there, you know. You get these indicators that are played in this or that way. It's mere arbitrariness. It has nothing to do with real legal certainty. Now, this finally has been discovered by my colleagues, you know, and we started, and myself, of course, we started a big debate. And then we said, now we need the legislator to do something, to bring us a definition of what an employee is. And then we got the definition in 2017. And I read it for you because you have to hear this, otherwise you won't believe it. It says, an employee is any person who, pursuant to a civil law contract, is obliged to perform, subject to instructions, work determined by a third party in relation to whom the person is personally dependent. The right to give instructions can concern the content, performance, time, duration, and place of the activity. An employee is any employed person who cannot essentially determine freely his/her activities and his/her working hours. The degree of personal dependency is also determined by the specific nature of the activity in each case. All of the related circumstances must be given consideration in determining whether a person is an employee within this sense. If the actual performance of the contractual relationship demonstrates that it is an employment relationship, the designation in the contract is irrelevant. What is this? It is nothing else but a simple transfer of what we had as judge-made law into the legislation. It means nothing, you know, and it is as vague and as irrelevant as it was before. In other words, we do not have anything which tells us what subordination means. We only know that subordination as a category cannot cope anymore with the complexity of working life. That's what we know. And we have lots of indicators, but this doesn't help, because as we know more and more, the more we discuss and the more as we can see written now. If, for example, you look at the writings of my friend Brian Lenshaw, you will see that he has shown that any sort of multi-factor assessment of what an employee should be doesn't work. It's just alibi, it's arbitrariness. But to be clear, I do not want to blame the legislator, because I have to admit, and we all know this, I don't have to go into this, that the technological and organizational developments we have faced in the last decades, and we are still facing, of course, make it difficult to find a sort of category which would provide us a clear-cut demarcation line. This is simply not possible. And if this is not possible, the question is what to do. And now I come to my second part. Well, first of all, from an analytical point of view, I fully agree with Professor Perulli that we have to overcome the binary system subordination autonomy as a ratio of labor law and establish new normative categories. But in order to make, as Professor Perulli writes, the worker a homo faber and not an animal laborans, we would have to overcome the system of capitalism, because, as Professor Perulli correctly tells us, all work is actually an instrument of capitalist production. And if that's true, well, we have to overthrow this if we really want to step from the sphere of necessity to the sphere of freedom. You know, it's not that easy. And of course, the idea to overthrow the capitalism, I think it's a little bit unrealistic. So I'm not sure whether we should go that kind of path. Well, what do we have to do? We have to protect all those who are, and now I take again this terminology, in the sphere of necessity. But then we have to understand that the sphere of necessity is nothing but an analytical category. And it doesn't explain what this means in practical terms. Therefore, the big question for me is, secondly, what has to be done in practical terms? And here I suggest a radical change of paradigm. Instead of putting workers in different categories, employee, employee-like, self-employed, and I don't know what, you know, it might be preferable to discuss the floor of rights all working people need, no matter what their status is, in particular, what their contractual status is. This suggestion is not original, I have unfortunately to admit. It is in line with the idea of the universal labor guarantee as it was suggested by the ILO Commission on the Future of Work. And unfortunately, it's no longer contained in the ILO Centenary Declaration of June 2019, which I think is a pity. You know, it should be rethought. What is this? Well, it focuses on protection of workers, regardless of their contractual arrangement and of their employment status. The focus, that's my suggestion. The focus should be on the shape of the protective umbrella, not on the boxes where workers are put in. This, I have to admit, is difficult, because at one place we have to make a distinction between those who deserve protection and those who don't deserve it. And there we have again a problem of drawing a demarcation line, which is similar to the problem I was discussing before, you know. And how we are going about this, as far as I can see, nobody could give me an answer so far, you know. There will, of course, be many people, entrepreneurs, who are outside of this area where we have to call about protection. But there are many who are in, you know, and here to draw the demarcation line is as difficult as what I told before. And there is another problem, which in my view is a problem which is not enough discussed. And the problem is, if we are broadening the scope of protection, we have to give an answer. Who is responsible for making sure that this protection is executed? Or to put it differently, if there is not an identifiable employer, who should take over this role? This, by the way, is a very old problem and a well-known question. It didn't come up with platform work, you know. Everybody thinks today that things come up with this kind of platform work. That's not true. You know, I work for many, many years in developing countries, in particularly in Africa. And you may know that in developing countries, more than 80%, sometimes 90%, as in India, is not formal work, but informal work. And in the informal sector, you have no, or in most cases at least, you have no identifier employer. And if you provide protection, the question is, who is providing it? Who is guaranteeing that this protection is not only in the books, but in reality, in practice? And to a great extent, at least in the informal sector, it's now the state. And the big question is, will the approach which I'm suggesting also end up in discussing whether and in how far the state has to guarantee that those who are to be protected really are protected? These are questions for which I have no answer. You know, in my age, you can put up questions, you know, and the young people one day will answer them. So I leave you with this and wish you a good discussion and hope that I can stay here for a while to discuss with you. Thank you.
Manfred, thanks very much for this very clear and again thought-provoking intervention. I think you mentioned, well, you touched upon both in your first part and in the second part, some of the developments and the features that we have seen also in other jurisdictions, and that's very interesting from a comparative perspective. And both the question on who is the employer and the way our section 611 of the BGB has been reformed, it frankly, it reflects very much how the jurisprudence has evolved in the last couple of decades. No, I would say more decades. Yeah. So with your intervention, I think that was really the cherry on the cake of this seminar, because all discussants so far engaged into two main works. On the one hand, they gave us the chance to get a grip on their own legal system, so they gave their own perspective about the topic. But on the other hand, they engaged all of them in a very frank and direct dialogue with Professor Perulle's points, which is all the more interesting because this is meant to be a proper seminar. Now, unfortunately, we are all online, but we could have been around a round table. And I think that's the second aspect of the discussion we had so far is probably the most interesting one. And since we have approximately half an hour to go, I would like now to open the discussion. And in particular, I would like, first of all, to ask whether Adalberto wishes to pick up some of the many, many issues that have been discussed so far. And secondly, so maybe in a brief, so to say, reply. And secondly, whether someone from either the organizing committee or from our early career scholars would like to intervene, give their own perspective, because I think that the mandate that Manfred expressed a few seconds ago is definitely a mandate which must be put on the shoulders of the younger generations. And therefore, I think that's quite a challenge, but that's the wonderful thing of being here in such a discussion. So first of all, Adalberto, thanks very much. If you would like just to, I don't know, it's very difficult, of course, to pick up all of them, but go ahead.
Thank you very much, Luca. Of course, I've learned a lot from my colleagues, and I would like to thanks a lot all the colleagues who discuss the issues, taking into account my papers. I would like to react first of all with a methodological question concerning the intermediate categories, saying that intermediate categories should not be confused with false or bogus self-employment, because we are referring to true self-employment, which has particular characteristics with respect to the general self-employment. Let's think about, for example, the cases indicated by Jesus with reference to self-employment inserted into the outsourcing processes and the other conditions that connote work in terms of dependence and alienation beyond subordination. There is an article of Jesus which clearly states that we can see that alienation is a condition of self-employment when we distinguish the different situation of self-employment. Therefore, the intermediate categories are not to be conceived as substitute categories of subordination. And this is very important, they do not reduce the rights of employees. They simply broaden the sphere of rights of these self-employed workers. And I think also that many rights must be extended to self-employment in general, not only to economically dependent or other categories. Think about trade unions' rights, think about collective bargaining, think about welfare, social security, and so on. Are these intermediate categories functional to capitalism? David wonders about that. And my answer is certainly yes, as is for the category of subordination, of course. But I think that in the case of self-employment intermediate category, they are also functional to the worker, who today do not necessarily want to be subordinate and prefers to be considered as a self-employment worker. Of course, with social protections, with a set of social rights. Let me say that I did a lot of seminars with the media freelance that Manfred talks about. And in these seminars, these young workers, because they are still young workers, they said to me, we don't want to be employees. We don't want to be employees. We want to know, for example, if the compensation we receive by the client is fair. This question. This they need. And of course, they would like to be able to negotiate the terms of their self-employment contract with the newspaper or television and so on, without being under the domination of the clients, under the domination of the client's bargaining force. And this is the first consideration. The second consideration is more political and is about the value of subordination. The value of subordination. My impression, and I say this very clearly, my impression is that an ideology of subordination has been built by the jurist, and if one wants to be progressive, must necessarily recognize the value of subordination, the quality of subordination, as if the qualification of subordination is the salvation of the humanity. But this position forgets that subordination is above all a condemnation in Marxist analysis, a condemnation, a deprivation of liberty, often a condition of exploitation. Becoming an employee is not a class struggle. Huh? is not a class struggle. But some scholars think about subordination as a class struggle. So third consideration, does labor law want to contribute to the freedom of the subject, of the worker? I think that this answer deserves an affirmative answer. This question deserves an affirmative answer. Labor law must protect the autonomy, the independence of work, professionalism. So to answer Thomas' question, certainly the legal system which contributes to creating social reality, I agree with Thomas. The legal system must promote not so much subordination, but freedom, and to guarantee the condition for a truly free work, such as the intellectual work and the scientific work, the geistige Arbeit, who then became subordinate, as Manfred reminded us with the reference to the doctor. And I would like to remind you that the doctors in Europe until the 17th century were paid by the client only if they get the result, only if they get the result for the client. So they were truly self-employed workers. And in this perspective, it is important to, of course, ensure control over the works, over the production process, participation in the construction of the organization of work, training, and so on, to guarantee safety, professional growth, moral growth of work. Does this mean overcoming capitalism, as Manfred seems to say? I do not believe. I do not believe. I believe that we have to put forward a normative program, of course, in order to give a statute to the work in general. And I have to say that until now, this statute of the work in general doesn't exist, simply doesn't exist. And then I completely agree with Manfred when on the perspective of a universal basis of rights for all workers. And this is, in my perspective, universalism. Then we need, as Manfred said, we need to identify the protections and how to do this. This is the task of politics. This is the task of politics, not for jurists. Sorry. An example, and I finish here, an example, very simple. When self-employed workers were hit by a sharp reduction in work during the pandemic, it turned out that there was no income support for them, for these workers. And a form of protection finally has been extended. So this is a case. But, and this is my answer to Manfred, in my opinion, and this is the selectivity, universalism and selectivity, and this is the task for the politics. Thank you very much.
Thanks very much, Adalberto. I have somehow the feeling that the meaning of this exchange between your writings and the colleagues can and should be the beginning of a bigger conversation. And for sure, it's not the end of this conversation, particularly because we all left, we are all leaving many doors open here for discussion. Now, in order to nurture again this discussion, I see that Manfred would like to react.
Adalberto.
Yeah, go ahead, Manfred.
Adalberto, I agree with you. I agree with you, but I would say, you know, and this is something we have to discuss, and which of course is difficult. I'm not sure whether you can distinguish, as you do, politics and law. You know, I think one of the big achievements of people like Hugo Sinsheimer and Karl Freund was that legal policy and law cannot be separated and has to be seen as a sort of unity, one action, you know. And therefore, I agree with you. It's a question of politics. But law, to a certain extent, is nothing else but the outcome of politics. So if we distinguish the two, we run in perhaps problems which distance law in a way from society which is not appropriate.
Yep, Adalberto.
Of course, I agree with Manfred. It was not my intention to separate politics and law. But of course, we are here to discuss, and we are lawyers, we are not politicians. So this is the demonstration that there is no separation between the two spheres, of course, but I totally agree with you.
Of course, if any of the discussions would like, the discussants, sorry, would like to come back to some of the points. I think we touched, I think that in the reply from Adalberto, he touched on two items that were here and there in your interventions. One is the protection of fundamental rights, and the other one is the role of social security. Of course, all this has different layers of analysis, both at European and at domestic level. You know better than me that at European level, something is moving, at least in the last years. Then we will see what will be the place of fundamental rights. Now, Adalberto mentioned collective rights and others, but I think there's a wide, palette of fundamental rights that are in question here. So does anyone want to come back to some of those points? because in case you don't, I think that Tanya could introduce, so to say. Oh, Thomas, go ahead, vas-y.
I'm sorry, I'm going to try to respond in English, but maybe it will be a catastrophe. I agree with all my colleagues, and I think that the big question, there are a lot of big questions. For example, who is employer? Who is employer? And you know, in France we have a whole thesis of 1977. And the question, it was about the employer, and the great question is, who is employer? And we have the same question today. This is the same question. And I think I agree with the other fact that we can separate the question of labor law and the question of welfare state. Who paid for all these things? I just want to remember, maybe the first question is, what is labor law? Precisely, what are the functions of labor law? If we pay attention about history, for example, we can see that labor law schematically is three function, three posture. First one, it is an instrument for protection the person at work. Okay, the labor law construct like that. We want to protect the body, health, to give an economic protection. Secondly, labor law is an instrument for controlling power, for controlling décision arbitraire, the employer power. And at last, from the 17th year, we see that labor law becomes an instrument of protection of the fundamental rights of workers. It is schematic, but then you can find inside labor law three figures of what is an employee. First of all, it is a person at work, but like Adalberto says, he is subordinate, then he loses freedom in his work, in his mind. He is submit to an order, to aims that he has no control about. The second figure is the dependent worker. What does it mean? Is a co-contractor. I'm sorry, I speak about contract because, you know, in French law, the contract is determinant figures. Then is dependent worker. It means that the control of his prestation passed by the contract sometimes, and that is controlled by, for example, directive control, but sometimes it is in the contract by some stipulation in contract. And the third figure is is the worker, not in the English or common law term, not because of the statute. Is a worker, like we said in France or in the Italian word. C'est le travailleur without adjective. Okay. And I think that when you think the labor law like that, you can separate different function and then find rationality different to finally think the extension of labor law. It is not a question of universality of labor law, but universality of some rights dedicated to realize particular function. And this is why in my speech, I talk about power in self-employment. Because I think that labor law can say something about fundamental rights, collective bargaining, decent wage, etc. But there is a particular problematic for controlling power by contractual prerogative, which is a question for civil law. For civil law, how to control sometime power in self-employed contract. And I think that you can coordinate labor law and civil law, for example. And in France, it's very clear because, for example, you have a reform of civil law in 2016. And civil law integrates labor law mechanism, for example, the control of procedure, the control of motives when you made a rupture of the contract. And I think there is a discussion and that the figure of dependent worker have to be synced and placed in this perspective. And you have the third perspective, the one of the worker in general, without adjective. And you can think, for example, that the collective bargaining rights, the equality, the non-discrimination policy is not only a question for subordinate worker. This is a question of protection for the person at work, sans distinction. And then I agree with all my colleagues, but I just want to say that we have to precisely understand what are the aims, what are the function of labor law in order to think how to extend some rights. I'm sorry for my English. Thank you.
No, Thomas, I think it was very, it was very, very clear, to be honest. Particularly, I mean, the way you mentioned the so-called stipulative definitions, so definitions that are based according to the purpose of that piece of legislation or that area of policy. Of course, that's another way to look because of course civil law countries are more used to use general concepts, I mean overwhelming concepts that encompass everything like umbrellas, but the way you mentioned the stipulative definitions, that's another approach. So it's to say, okay, we look at the purpose and then we see, okay, who can or should be protected under this purpose, and it can be of course different from one box to another. That's a very interesting perspective.
May I react just a second about
Sure.
Thomas, the Thomas perspective? I think that the idea of labor law that Thomas gave us is a little bit narrow. I have no problem to integrate, as Thomas said, different techniques, labor law, private law, contract law, of course. It's okay to me. But the risk, in my opinion, is again move the problems concerning regulation of self-employment to the sphere of private law. And this is very problematic to me. I prefer to consider labor law also as the law of self-employment, as Gérald Yoncan, le seul juriste en Europe qui a proposé, the only jurist in Europe that proposed the creation of a true system of labor law for self-employment, integrated, of course, with the general system of labor law. And another reaction on for Luca on fundamental rights. I would also like to add at the list of the fundamental rights the right to have a fair compensation, a fair remuneration. Sorry, a fair remuneration. We know in Italy there is a constitutional norm, Article 36 of the Italian Constitution, but jurisprudence has always interpreted this norm as a norm referring to subordinate work. But let us remember that many self-employed workers, economically dependent workers, has lower remuneration than a compared employee. So this is a fundamental right for me. And here we cannot say, okay, think about this problem as a contractual problem, a problem of justice into the contracts. Apart that, it's very, very difficult to dialogue with the private law colleagues about that.
Exactly.
Because many colleagues, private law colleagues, told me doesn't exist the justice in contracts. So it's ridiculous that you arrive from labor law, you arrive in our topics and talking about the justice of the contract. So this is the risk to move again the problems of regulation of self-employment inside civil law, private law. This is my feeling. Thank you.
Thanks. Well, for the curiosity that all these remarks may raise, I think we would all stay 2 days here connected and keep on discussing these topics, isn't it? I mean, I have now this feeling, but of course we have all our lives and constraints, professional and personal constraints, and it's Friday, so we cannot see each other for the next 3 days. This is unfortunate, but I'm sure that what is going to happen thanks to this first seminar is a very nice things, because we are really boosting and we are facilitating a dialogue that now makes much more sense for us and for the speakers of today and for young lawyers. Now, of course, we are not obliging at all the speakers of today to be present in the discussion of this afternoon and tomorrow, but we will keep record of all this, and then let us circulate to you all the results of the group, of the work that will be done in the groups. And to this end, we may, since it's past, we may consider concluded this seminar. Let me thank warmly all the speakers of today, Adalberto for his engagement in this very nice discussion, and also the official discussants, because I think we all learned a lot today. Thanks very much. And yeah, virtually clapping hands to you, to us all, and thanks for the organization to the labor law community. And we see Marzia there. Thanks very much.